This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Hello and welcome to The Explainer. You know, we all make promises every single day. But when does one of those casual promises cross the line and become a full-blown, legally binding contract that you could actually be sued over? For your SQE exams, knowing exactly where that line is, well, it's absolutely crucial. So let's get into it. Okay, so here's our roadmap for today. We're going to look at what makes a promise stick, we'll explore the two different legal worlds that agreements live in, and then we'll break down the rules for deals with family and friends versus deals in the business world. And to wrap it all up, we'll cover two final but super important health checks: certainty and capacity. So, let's kick things off with a simple one. You promise to meet a friend for a coffee, but life gets in the way and you totally forget. Can your friend actually take you to court for the price of that latte? I know, it sounds completely ridiculous, right? But believe it or not, this exact question gets to the absolute heart of contract law. And the answer all comes down to this one key idea: intention to create legal relations. It's a bit of a mouthful, but all it really means is this. For any promise to become a contract, the people making it must have intended for it to have real legal consequences. They must have meant for it to be enforceable in court if someone backs out. Without that intention, all you've got is a broken promise, not a broken contract. So how on earth do courts figure out what people were intending? I mean, they can't read minds, right? Well, instead, they use this really practical system. They start by placing every single agreement into one of two different worlds: the social world or the commercial world. This slide right here gives you the perfect mental map for this whole topic. You've got the two worlds, social on one side, commercial on the other. And the most important thing to see is that their starting points are total opposites. The law has a different default setting, or presumption, depending on which world your agreement falls into. Okay, let's lock in this term because it is so important for your studies. A rebuttable presumption is simply the law's starting point. It's the automatic assumption a court will make right out of the gate. But the key word here is rebuttable. It means this assumption isn't permanent. It can be overturned or rebutted, but you've got to bring some pretty strong evidence to do it. And here are those two opposite starting points. In a social or domestic context, like that coffee with your friend, the law's default is to presume there's no intention to be legally bound. But in a commercial context, it's the complete opposite. The law presumes there is an intention. They are perfect mirror images of each other. All right, let's see how this actually works. We'll start in that first world: social and domestic agreements. This is the world of promises made between family members, partners, and friends. So, this is your key takeaway. When you're looking at a scenario question involving a promise between, say, a mother and daughter, your default setting is that it's not a contract. And the law does this for a very good reason. It wants to avoid the courts being flooded with lawsuits over every forgotten birthday promise or family squabble. It just assumes these arrangements are based on trust and love, not legal force. And that is why your friend can't sue you for that coffee. But, and this is a big but, remember, it's just a presumption. It can be knocked down. How? Well, the courts look for clues. This slide shows two big ones. First, how certain were the terms? A father promising money for as long as he can is just way too vague. But second, what was the relationship really like at the time? A couple that's separating and making a formal agreement about their house, that's not just a friendly chat anymore. The serious, not-so-friendly context is strong evidence they intended it to be binding. And here are two more really powerful factors. First up, the sheer seriousness of it all. A formal prenuptial agreement signed and witnessed, that's obviously meant to be legally binding. And second, and this one is a really big deal for the courts, has one person relied on the promise. So in this example, the niece quits her job and sells her flat to move in and care for her relatives. She has acted on that promise and changed her whole life. That reliance is incredibly powerful evidence that this was much more than just a casual family arrangement. Okay, let's leave the family home and head into the boardroom. We are now crossing over into the commercial world, and in this world, the starting point is flipped completely on its head. This is the absolute bedrock of business law. When two companies, or even just two people, are making a deal in a business setting, the law's default assumption is that they fully intend for that deal to be an enforceable contract. The tables have turned. Now the burden is on the person who wants to argue it wasn't a real deal. So how do you push back against this really strong presumption? Well, it's not easy, but it can be done. And the number one way is to use crystal clear language right there in the agreement. Phrases like binding in honor only, or the classic subject to contract, are like giant flashing signs telling the court, hey, we're not ready to be legally tied down yet. You can also argue extreme uncertainty, but honestly, courts will bend over backwards to make a commercial deal work if they possibly can. If you ever see words like these in a document, that's it. Game over. This is the clearest possible signal you can give a court. The parties are spelling it out, leaving no room for doubt, that they do not intend to be legally bound. This is pretty much the most effective way to rebut that strong commercial presumption.
Another important element in the commercial legal world are comfort letters. A comfort letter usually comes from a parent company to a lender when the parent company won't give a full guarantee, but wants to reassure the lender about a subsidiary's debts or position. It often signals support without promising to pay. These letters are different from a guarantee where the parent company undertakes liability. In many commercial situations, comfort letters are not meant to be binding, however. They can be if the language reads like a promise. Let's take a look at some examples of these. In Kleinwort Benson against Malaysia Mining, a bank sought a binding commitment from the parent company. The parent company refused to provide a guarantee, but sent a comfort letter saying, in substance, it is our policy that the subsidiary will be able to meet its liabilities. When the subsidiary later defaulted, the bank sued the parent company. The Court of Appeal held the letter was not a binding promise. Why? Because it read as a statement of present policy, not an undertaking as to future conduct, and the surrounding fact that the parent company had refused to provide a guarantee cut against an intention to be legally bound. Now, in the case IDBI Bank Ltd. Against Axel Sunshine, the document was labelled a letter of comfort, but the High Court read the substance and held that it actually created a guarantee and indemnity. The court enforced it, allowing the bank to recover under an unpaid loan. So, what does this all mean? Clear promise language and risk-bearing terms can show intention to create legal relations, even if the document is called comfort and not guarantee. But how do you know if comfort letters reads as binding or non-binding? Well, certain phrases tend to look non-binding, such as, it is our policy, we intend to support, we are confident, plus express caveats like not legally binding or subject to contract. In contrast to binding phrases such as we guarantee, we undertake to pay, primary obliger, on-demand indemnity, or a promise triggered by default with no further conditions. All of this sits under the general rule that even when consideration is present, an agreement isn't binding without intention to create legal relations. Courts assess intention objectively from words and context, and comfort letters are part of that principle in commercial situations.
So you've done the hard work. You've figured out the context, you've applied the right presumption, you've looked for any evidence to rebut it, and you're pretty sure you have a contract. But hang on a second. Before that agreement gets the final stamp of approval, it has to pass two last little health checks: certainty and capacity.
The first check is certainty. Basically, a court can't enforce a deal if the terms are so vague they can't figure out what the parties were supposed to do. If an agreement is void for uncertainty, it means it has no legal effect whatsoever. It's a complete nullity. It's like it never even existed in the first place.
And the second check is capacity. This one is all about the people who made the deal. Do they actually have the legal ability to enter into a binding contract? The law steps in to protect certain groups, like children or people who lack mental capacity, by saying they can't always be held to the contracts they make.
Now, this brings us to another key term, voidable. This is different from void. A void contract was never really there. But a voidable contract, well, it's a perfectly valid contract unless the person with the remedy, the person the law is protecting, decides to cancel it.
And this classic little case is the perfect example of capacity in action. Now, minors are bound to pay for things that are necessaries, like food, shelter, basic clothes. But in this case, the court said that 11 fancy waistcoats were definitely not necessaries. So, because the minor lacked the capacity for this kind of luxury purchase, the contract was voidable, and he wasn't bound to pay.
All right, let's pull all this together into your essential SQE cheat sheet. 1. Always identify the context first. Is it social or commercial? 2. State the correct presumption for that world. 3. Go on the hunt for evidence to rebut it. And a few quick hits to remember. Comfort letters from parent companies are usually not binding. A contract with a minor for luxury goods is voidable. And an agreement that's too vague is just plain void.
And we'll leave you with one final thought to chew on. We're surrounded by ads every day, all making these wild claims and big promises. So, thinking about what we've just discussed, at what point does all that marketing talk, what lawyers call mere puff, cross the line and actually show an intention to create legal relations, turning that ad into a promise that anyone, including you, could accept? We'll see you next time on The Explainer.